Calling case number 22397142. This is DRF5Q0QOZB LLC versus James West and all occupants at 15335 Wilderness.
Sean Norsegian, P77410 on behalf of plaintiff.
Truth Science here on behalf of YouTube, Your Honor.
James West, appearing as pro se, Your Honor.
Thank you, Mr. West. Today is the date and time for an adjourned hearing to address defendant's motion to dismiss. Court is in receipt of the motion filed. Opposing counsel is also in receipt of the motion filed. So, Mr. West, this is your motion.
Very well. Your Honor, let me open up by stating that I am a student of human rights law and a student of indigenous law and international law, as well as domestic law. I'm actually planning attending law school to join you guys in the bar in the near future.
Somehow I seriously doubt that. By the way, where is this gentleman? Is he phoning in? Because he's not on the Zoom call. Where is he?
Sure. So the way that I had to frame this case was because of the nature of the summary proceeding. And I know this is not how it's normally done, but it was the only way that I could think of to do it. So bear with me. There may be a few glitches here and there pertaining to the case. But my motion to dismiss is based upon MCR 4.201, in particular, Section D. I'm the only person that could have received personal service. Now, I know that the court says it has proof of service on file, but I have not seen that, nor have I seen or had an opportunity to cross-examine whoever said they served me personally or any occupant. And that's the reason I'm dismissing the case, because 4.201 Section D says that it must be served in a manner or upon someone in the household of suitable age, and the content of the service must be revealed to them. And that has not been done.
What about 4.201 D3? What does that say?
I don't have the statute in front of me, Your Honor.
Read it. I'm gonna read it for you. 4.201 D3 says, after diligent attempts at personal service have been made. Okay.
That's right. That's right. In addition to
by securely attaching the documents to the main entrance of the tenant's dwelling unit. A return of service made under this sub-rule must list the attempts at personal service. Service under the sub-rule is effective only if a return of service is filed showing that, after diligent attempts, personal service cannot be made.
Okay, so far what I'm gathering here is that this man on the call wants this case dismissed because he wasn't served. Now, I'm pretty sure that he wasn't served because he has been hiding from the person that has been trying to serve him. So just like the judge read, that as long as multiple attempts have been made to try and serve somebody, then that's it. They can put it up, tape it to your door. That's it. So this man's loophole is no longer a loophole. The judge just trumped him.
An officer who files proof that service was made under the sub-rule is entitled to the regular personal service fee. So,
right.
I have a proof of service for this matter served by Carlton Carter, the court officer at 36th District Court, that states a diligent attempt was made on December 19th, 2022 at 8:51 a.m. Another attempt was made December 23rd, 2022 at 6:13 p.m. Switch the time up. And the last attempt was made on December 28th, 2022 at 12:44 p.m.
Okay, well, diligent attempts is not serving or attempting to serve 3 times. Diligent attempts, according to the legal literature, actually means that you tried to find the defendant's job where he worked at.
No,
And
we're not making up new definitions.
I'm not making up any either, Your Honor. I'm just explaining what the legal literature says. A diligent attempt doesn't mean.
What literature are you quoting? What legal literature are you quoting?
Excellent question, Your Honor, because we're not just going to sit here and believe what this man is saying, because how do we know that he isn't just making things up for his own benefit? Get us a citation, sir.
Just over the years of studying this, I've done this. I've done.
Hold on, Mr. West. I'll let you talk.
Okay.
I need a citation. I need you to cite this. We can't. This sounds like a little bit of barbershop talk. If I don't have a citation, then it may not be legal literature that's applicable to the Michigan court rules or, the state of Michigan or the United States of America.
Okay,
So,
well, we can check juris secundum or am juris. That's the legal literature that I studied.
Today's the day and time for you to argue your motion, and based on MCR 4.201 D3, diligent attempts were made. Affidavit was filed. Service is proper. Now you can appeal that hearing. However, I'm granting proper service. Now you had a motion to dismiss for insufficiency of process of service. So that is one that you can appeal, but I'm denying that motion to dismiss on those grounds. But
okay,
you have
Judge, if I could,
go ahead. Go ahead.
Mr. West, we do have legal aid here available. If you'd like to speak to an attorney from Lakeshore Legal Aid about your case, we may be able to help.
We're in the middle of the case.
I'm sorry, Your Honor, I didn't hear what you said. I heard some gentleman come in.
Mr. Narsigian, do you have anything to say?
I agree with everything that you said, Your Honor, regarding the service. As far as the rest of Mr. West's claims, while I wish he was right, it would be great if we didn't have to pay property taxes. The fact is that we do. So that's
Objection, Your Honor.
Position.
Objection, Your Honor. That's beyond the scope of the pleadings. The attorney filed a landlord tenant case. This is not about taxes. So on his complaint, he has something about that in section CH on his complaint that my lease was terminated. There's no evidence in the record about he and I ever having a lease. So he's flipping the switch and talking about taxes. He said that I am his tenant. That's not the case at all.
This is not saying that. This does not say that there was any lease that existed.
Now, this man talk about someone flipping the script. Sir, that's exactly what you're trying to do. You just stated that the owner said something about a lease, but the court knows nothing about a lease. This is why you need legal counsel. Get help.
I don't think there is any allegation of a lease existing. So, okay. Motion to dismiss for fail. Let's get to all these. On page 12, that was your motion to dismiss for lack of personal jurisdiction. So, have we established the fact that MCR 4.201 D3, we've established the fact that diligent attempts were made according to the affidavit stated by Carlton Carter that service is proper by attachment. So you have other motions. You have a motion to dismiss for failure to state a cause of action, lack of subject matter jurisdiction, petition for a temporary injunction. So which one would you like to argue next?
Well,
Mr. West?
no cause of action, in part because I have no agreement, never had an agreement with this corporation or the attorney, none of that. And again, he's alleging that this is a leasee complaint.
Excuse me, sir, but the judge just explained to you that he is not alleging anything about a lease. You need to listen, and you also need to get yourself a lawyer.
So he must prove that. I don't see any evidence that he and I ever had any agreement.
Mr. Narsigan?
At no point did we allege that this is a leasee lessor situation. The property was purchased at tax auction in September of 2022.
Objection, Your Honor. Again, this is beyond the scope of the pleadings. This is not a tax case.
That's the beauty of this, Mr. Narsigan. Please continue.
I like this judge. This is the first judge that I've seen that actually muted a defendant. Normally, these judges just let these people ramble on and on and on, interrupting the court. And I've never understood why. You're on Zoom. You can simply mute a person. So just mute them and take lessons from this judge.
Okay, so the deed was recorded October 6th of 2022. I believe at some point in November, we sent a 30-day notice to quit so we could gain possession of the property. Obviously, self-help is not a remedy in Michigan, so we can't, kick him out of his own house. We go through the eviction process, and that's where we are. This was a summary proceeding that we filed. We provided him with a 30-day notice to quit. He didn't move. We filed the case. I think this is the third hearing that we've had now. We're, 6 months past when title passed to my client at this point. So we have standing to file the case. And there's no need for a landlord-tenant relationship in order to file an eviction case. And that's our position.
I'm going to unmute you, Mr. West. Well, I'm asking you to unmute. Mr. West? Mr. West? Mr. West?
Can you hear me, Your Honor? I'm here.
I can hear you. Can
Yes.
you put your camera?
Say that again, Your Honor. There's some interference.
I was asking, could you put your camera up, but you can continue.
Okay. Once again, Your Honor, I haven't heard the plaintiff state any law that he's standing on. This case, he's still talking about what happened at an administrative hearing. The court here doesn't have any jurisdiction to hear any administrative hearings.
Hold on. Let's rewind that.
Okay.
Are you referring to Wayne County foreclosure?
Yes, all of that. Yes, Your Honor, because the court only has jurisdiction.
Hold on, please.
Oh, God.
The Wayne County foreclosures occurred in Wayne County Circuit Court. It's not an administrative court. It is a circuit court filing that Wayne County files against the landowner or the property owner. These are Wayne County Circuit Court cases. And yes,
I-
that's jurisdiction, but that's the reason why this case was filed. This case was filed because plaintiff obtained a deed from the Wayne County auction. Whether he obtained it from the Wayne County auction or obtained it from someone who sold him the property, he has a deed. That deed states that he owns the property of 15335 Wilderness. By law, anyone who has a deed may file an eviction. There's not a requirement that someone has to have a lease to file an eviction. This matter was filed as a complaint to recover possession of property. There's no allegation when you file a complaint to recover possession of property. There may be an allegation of a lease expiring, but based on the complaint, 5B was checked. As you noted, because you're aware of the complaint, because you quoted the complaint. 5B states that tenancy was terminated by notice to quit. What is the notice to quit? The notice to quit is the notice to quit to recover possession of property that was issued on October 24th, 2022, before this lawsuit commenced. So that is why the Wayne County auction is being referenced. There is no need to quote any law. This is just a story, a factual basis that establishes why we are here, why a complaint was filed to recover possession of property, and why Mr. Norsegian, on behalf of his client, has the right to file a complaint in this courtroom to gain possession of these premises.
So pretty much what's going on here is the man that is here in court representing himself lived in some type of house. That house was sold in an auction to someone else, and now the new owners do not want this man on the premises. So they're trying to get him evicted because they are now the new owners and they do not wish to have him as a tenant. So he's done. You have to go. Now, you know, they're not going to make you go right away. They'll give you 30 days, maybe 60 days. But at the end of the day, you have to go. You don't own the property, so you got to go. Plain and simple. It's time to move, Bob.
I'm going to object, Your Honor, because I'm going to object on the grounds that the foreclosure process starts with an administrative proceedings. That's with your father or the tax assessors, and then your father attempting collecting the tax and showing, or not your father, but the Wayne County treasurer attempting to collect the tax and have a show cause hearing. That's the administrative part of this process that I'm referring to. So
what
now,
does that have to do with us right here? What does that have to do with anything?
all of that's interrelated in the sense that because that was an administrative proceeding, that this court judicially only has judicial power to review whether those proceedings were done properly.
Excuse me, sir, but I've reviewed the files and they were done properly. You have no legs to stand on. You are not the owner of the property, so you have no legal claim to just stay there. It is time to move.
I don't have any power to review anything that's going on in the upper court.
That's my point. That's why I said he doesn't have any cause of action and the court has no jurisdiction.
The court has jurisdiction. This is the exclusive jurisdiction to hear landlord-tenant cases. Any property in Detroit with a parcel ID within the limits of the city of Detroit goes to landlord-tenant court. If I'm in Highland Park trying to evict someone, I can't evict them in 36th District Court. I have to go to Highland Park. If I'm trying to do it in Ferndale, it's not an Oakland County court. It's not Royal Oak District Court. It's going to be Ferndale District Court. This works for the entire state of Michigan and most likely the entire United States of America, because county courts won't have jurisdiction over local matters. And this here is a local matter. So
Okay.
I'm going to dismiss, deny your claim for your motion to dismiss for failure to state a cause of action. So you
All right.
have denied your claim for failure, for motion to dismiss for lack of personal jurisdiction. We've got it established that this is proper jurisdiction and service by attachment is proper, and personal service is not necessary in the landlord-tenant court, especially for a termination of tenancy. It's not a money judgment attachment. Court rules don't require personal service. Lack of subject matter jurisdiction. This is your final motion, I believe. So please argue.
Just give up, dude. All of your motions are frivolous and you are going to lose. It is time to move.
Hey! Ah, my pocket squares!
Well, it's all related upon the service of process, and you've already made a ruling. So you can just go ahead and make your ruling on the subject matter jurisdiction.
Okay. Said pursuant to MCR 2.116C 4, 5, 6, 7, 5, 6, 8, 9, and 10, the court must dismiss this case. What is MCR 2.116? You drafted this.
I don't have it in front of me, Your Honor.
Of course you don't.
I do.
Okay.
MCR 2.116C says the motion may be based on grounds of one of these grounds, but must specify the grounds on which it is based. Court lacks jurisdiction over the person or property. Exclusive jurisdiction over the property. The process issued in the action was insufficient. We just went over that service was proper according to MCR 4.201. So C2 won't work. C3, the service of process was insufficient. No, that's not a ground. Court lacks jurisdiction over the subject matter. This is the jurisdiction for an eviction. Landlord-tenant court. Doesn't get any better than this, the subject matter jurisdiction.
Well, he's raising the tax issue.
He's not raising the tax issue. The party asserting the claim lacks the legal capacity to sue. The party has the legal capacity to sue.
Okay, well,
6,
go ahead.
other action has been initiated between the parties involved in the same claim. Mr. Narsigian, is there another pending matter related to this case?
Not to my knowledge, and not that I filed.
All right, you didn't plead 7, you pled 8. The opposing party has failed to state a claim on which relief can be granted. Relief could be granted by entering a judgment in favor of the plaintiff. So that doesn't work. 9, the opposing party has failed to state a valid defense to assert the claim asserted against him or her. You have to argue. Do you have any argument? For 9?
No,
We're gonna let the pleadings speak for themselves.
exactly. Yes, Your Honor.
Okay. And except as to the amount of damages, there is no genuine issue as to material fact. No, there's an issue of material fact. So I'm going to deny your motion for lack of subject matter jurisdiction. Clause 3, Michigan Constitution of 1963, Article 628 says that this court has no power to review administrative action. You might be right on that, but this is not an administrative action, and we're not reviewing the merits of a foreclosure. I'm presented with a deed, a notice, summons, and complaint.
And Your Honor, just to be clear for the record, although foreclosures might start as administrative actions, they are processed through I know you know this, but just for the record, they're processed through the Third Circuit Court. There's a case number that's issued. And so it is a judicial action when the foreclosure is issued. And yeah, that's it.
Okay. Yeah, and the court understands it may start as a judicial action, but the foreclosure, as you stated, is a circuit court lawsuit with the case number. So, in order to adequately address your filing, you have a counterclaim. You're also suing. Counterclaim, there's count 1, count 2, count 3, and count 4. Do you want to argue your counterclaim, Mr. West?
Actually, I want to start with the my answers to the defendant's complaint.
Well, the court has then proceeded to the answers to the complaint. It's not, I'm not ruling on your answers. Counterclaim number 1, sham. The defendant commenced a complaint claiming to be a lessor of the defendant. Defendant did not file a false complaint. Just wanted to clear this out. All right. Mr. West?
Yes, sir.
Do you have any other arguments for the court?
The counterclaim is basically based upon the claim that the plaintiff is the lessor and I'm the lessee.
It's not, he's not alleging that.
The first count.
Okay, well, yeah, that's irrelevant because it's been established today that that isn't alleged in the complaint. That's not the allegation in the complaint. So you may say that H7 or box 7 that declares that this residential property was fit for intended use and has been kept in reasonable repair during the term of the lease. That doesn't imply that there's a lease. You can appeal that ruling, but the complaint states that you're here because tenancy was terminated by notice to quit. That's the allegation.
Why doesn't box 7 apply? It's checked off.
The Scrivener's error, Your Honor.
Right. Okay.
That's why this is a sham pleading. Now that was an error. Okay.
Yes, an error. It's an alleged error. Hey, go ahead, Mr. Narsighian.
I was just going to say, all due respect to Mr. West at this point, I have other cases in another courtroom that are about to be dismissed by Judge Sherman. And I mean, this isn't a sham. This is a legitimate complaint. Everything was done properly in this. I'm more than willing, out of respect to the hard work that Mr. West did on his motions, and I do respect what he did there. I'm willing to give him until May 1st to move out, which I think is more than the statutory 10-day minimum. That being said, I mean, that's all I have to say.
And Mr. West, do you agree to the move out date? May 1st?
Your Honor, there's some issues relating to my rights to own my property alone. which is an
Okay.
international issue.
What?
Excuse me, sir, but what in the doohickey are you talking about? How is this an international issue? Furthermore, you are not the owner of the property. It's just a shame. Sir, all of your arguments fell apart because you had no idea what you were doing. It's just time to face reality. These people are giving you adequate time to move out. It is time to go. That's it. Get out. Move out with some dignity. Don't destroy the place. And just move on with your life, sir.
All right, the court will enter. This is what we're going to do. The court's going to enter a judgment by hearing for termination of tenancy. There's proof of service in the file. Mr. Narsigian, when you forward over I did receive previously had a copy of the deed, but please forward that deed over with your judgment.
Yes, Your Honor.
The court is making a determination that there will be a judgment entered for all occupants with a move-out date of May 1st, 2024. So must vacate by May 1st, 2024. That's the determination, is the final determination of the court. Thank you, Mr. West. The court has reviewed your pleadings and considered your pleadings. And
I have an injunction. I have an injunction before the court as well.
well, the case is, the court is going to deny, the court is denying that injunction.
How can you deny an injunction? It's a complaint.
I deny your other complaints as well, but you may appeal this at the higher court.
All right.
All right. Good luck. Have a great weekend.
Your Honor, before you go, I have some objections that I wanted you to rule on. I've written them out. Do you have that? Are you in receipt of that?
No, this matter is concluded, Mr. West.
Okay. All right.
Thank you.
It's time to start packing, Mr. West. You have until May 1st to vacate the property.
Hey,